There is some confusion about when an order is appealable, so I'm going to try and address this in a sort of different way. We're going to the whiteboard. It's very possible I'm going to confuse you guys even more, but at the risk of helping someone, here we go. So we have case 1, which is Lively's case against Wayfarer. That's ongoing. And we have case 2, which is the Wayfarer party's defamation lawsuits against these guys and others, but to simplify. They're the defendants in that case. This is the case where they all filed motions to dismiss, and in June, the court granted those motions to dismiss. He did leave some room for possible amendment. Wayfarer parties decided not to amend, but that was the June 9th order, the 100 and some page order that granted the motions to dismiss. The big one that said that the Wayfarer parties couldn't allege actual malice and they couldn't amend their claims to survive legally. So that was the order. Now, in order to officially get out of the case, New York Times has to get a judgment. This is a requirement in the federal rules. You need entry of judgment to be officially out of the case. And the rules that govern this are, so FRCP are the Federal Rules of Civil Procedure. So FRCP motions to dismiss were filed under 12b6. That's the exact rule that it was filed under. And then Rule 58 requires a separate document for a judgment. That's just how the federal rules perceive a judgment to be perceived or conceived. The way to get a judgment when there are multiple claims and parties is through 54B, which is the rule that the New York Times uses in its motion for entry of final judgment. Rule 54B says, unless you get entry of final judgment, unless you get this, then an order or decision of the court, however designated, that adjudicates fewer than all the claims or the rights and liabilities of fewer than all the parties does not end the action as to any of the claims or parties and may be revised at any time before the entry of a judgment adjudicating all the claims and all the parties' rights and liabilities. So basically, until there's a sort of final judgment in the whole case, and I guess I'll just say in this all of case 2, then this could be amended. Hypothetically, it isn't often amended, but hypothetically it could be amended. So that's why once this happens, these parties want to get a final judgment because it means they're officially out of that case, and then that starts the clock for an appeal. So let me redo this for appeal. So again, the New York Times isn't just kicking this up because they feel like it. The New York Times wants to be out of this case. They want to be done. And so they want final judgment so that they can say, we are done. We are not in this case anymore. This was the court's decision. It was the correct one. Don't come and talk to us ever again. Now, what it does when there is an entry of a final judgment is start the clock on a party's right to an appeal. So we talked about the federal rules of civil procedure. Now we go to the federal rules of appellate procedure. These are the rules that govern what happens when you appeal a federal district court case. The rule under 4A, subsection 1, capital A, is that a notice of appeal must be filed with the district court. So here that district court would be the Southern District of New York within 30 days of, you guessed it, entry of the judgment. So remember, the defendants that got the order dismissing them from that case, New York Times, need to have an entry of judgment in order to be out of the case. And the Wayfarer parties need to have entry of judgment for that 30-day clock to start ticking for them to file their notice of appeal. So let's say the judge enters a final judgment on behalf of the New York Times. on October 1st, then the Wayfarer parties have until Halloween to file their notice of appeal. So this is a little bit different than how it's done in California. In California, you have 60 days from the time there's a file endorsed copy of a judgment. File endorsed means that the court stamps it with a date endorsing that it's sort of final. So you have 60 days from that point to file an appeal, or you have 60 days after the clerk files a notice of entry of order. So it's a little bit different terminology, same type of concept, but the procedure differs just a bit, especially with respect to the number of days. And in some cases, it can be up to 180 days after the entry of a judgment. There are rules upon rules upon rules that govern this. It's not worth getting into, but it's important to know that these rules need to be followed with respect to an appeal. Hopefully that clarifies some of the procedural questions. If you have more, drop them below.